Welcome, everyone. This is a National Veterans Legal Services program on the implications of the Supreme Court's decision in Soto on combat-related special compensation. This presentation is being recorded. The slides that you are going to see will be available on the NVLSP website next week. So if there's a slide that you feel you didn't get to see for long enough, you'll be able to view it at your leisure once it goes up on our website next week. And again, this webinar is being recorded. Next slide, please. So I am Rochelle Bobroff. I direct NVLSP's Lawyer Serving Warriors program, supervising all our litigation and training attorneys. I'm joined by two Army veterans. Next slide, please. I'm joined by NVLSP staff attorney Amy Fulmer, who works on discharge upgrades and CRSC claims. And next slide, please, as well as Sean Wojciechowski, who is an Equal Justice Works Fellow and trains attorneys to assist Special Operations Command veterans with DoD benefits. Next slide, please. This webinar is presented by NVLSP's Lawyer Serving Warriors Pro Bono program. Next slide, please. We are a free program. We never charge veterans for our services. We work with a network of law firms who provide free legal assistance to veterans, including on issues related to discharge upgrades, medical retirement, and CRSC. The photos that you're going to see on these slides, this one is two of our pro bono volunteers meeting with a veteran. You'll see NVLSP staff and you'll see our pro bono volunteers at clinics. And so you can see us in action. Next slide, please. The way that our program works is that veterans apply to us for our pro bono legal assistance. We always get a veteran's official VA medical and DoD personal records, and we evaluate each case. We go through the records to see if it's a good fit for our program, looking for meritorious cases that fit within the assistance we are able to provide. And if so, then we place it with one of our pro bono partners. The volunteer attorneys from our pro bono partners are lead, while the NVLSP or Lawyer Serving Warriors attorneys are mentors supporting the volunteers and remaining very involved, but not being lead. I do want to emphasize that we are not an all-purpose organization. We don't do any state law, divorce, custody, criminal. We do nothing of that sort. We are very limited in scope. And so there are many veterans who come to us for a variety of legal problems. We are limited in what we are experts in and what we handle. We are also not a lawyer referral service. So if you want a good lawyer for your divorce, we are not the place to go. We don't have a network that we refer to. Next slide, please. So today we are going to give you an overview of combat-related benefits, both CRSC and a brief discussion of CRDP, which will be defined shortly, but we're going to focus primarily on CRSC, different categories that are unique. It is not simply all conditions that occurred during service, like VA benefits. It is not everything that a veteran incurred while deployed to a combat zone. There are specific categories, and we're going to explain what those are. We're going to discuss the process for applying for CRSC and how to appeal. And then we're going to get into the topic that was addressed in Soto, effective date for CRSC. We're going to talk about the Soto case, class relief, and future cases. We're going to ask you to hold questions to the end. It may be that your question will be answered 2 or 3 slides down. So rather than taking questions as they come, there will be hopefully an opportunity for a few questions at the end of the presentation. We are not going to take any questions about individual facts. We are not going to give anyone advice about your cases. This is a webinar with general information. As I stated before, just to reemphasize, it is being recorded and the slides will be available on our website next week. Next slide. And with that, I'm going to turn it over to Sean.
Thank you, Rochelle. I'm Sean Wojciechowski, and I'm going to be discussing an overview of combat-related special compensation, CRSC, and concurrent retirement and disability pay, CRDP. Specifically, we're going to look at what each benefit is, the eligibility criteria for each benefit, why we need them, and what are some key differences between each benefit. Next slide, please, Amy. So first, we're going to look at CRSC. CRC is an extra payment that's in addition to your military disability retirement pay and or your VA disability compensation that a veteran receives monthly. It's importantly, CRC is tax-free and it's provided by the DoD rather than through the VA. It's available to any eligible veterans who have injuries that are combat related as defined by law. Combat related, as we'll talk about later, is broken into different categories. And while these categories go beyond simply did the injury occur in combat, there are specific definitions for each individual category that have to be met for that condition to be found combat related within that category. And finally, veterans must apply for the individual conditions. So if you have 8 conditions that you believe are combat related, you would have to file a separate application or a page 2 for each of those individual conditions. Next slide, please. Who's eligible for CRC? So the first primary marker for CRC eligibility is that you have to be in a retired status. That's either a medical retired status or years of service, which is typically 20 years. You must also be entitled to your military retirement pay, and that pay has to be being reduced by VA compensation. And you need at least one condition rated by one combat-related condition rated by the VA at 10% or higher in order to receive money. It's important to note that you can get CRC for 0% rated conditions, and they can be found eligible for CRC. And you might want to do that if you believe that that condition will raise over time beyond its normal progression. Next slide, please, Amy. In contrast to CRSC, CRDP is a separate benefit. It's automatic. There's no application needed, and it's for veterans who have sufficient years of service, once again, usually 20 years, and a combined VA disability rating of at least 50%. Now, unlike CRSC, CRDP is not based on combat. So any VA rated condition for any reason is eligible for CRDP. CRDP is taxable, however, unlike CRSC, which is non-taxable. And CRDP is taxable in the same manner that your military retirement pay would normally be taxable. Next slide, please, Amy. Importantly, is that you cannot receive both CRDP and CRSC. You have to elect one if you are entitled to both. CRDP allows veterans to receive the full amount of their VA disability and compensation and military retirement pay based on your total rating. In contrast, CRSC is a partial restoration of that military retirement pay based on your individual conditions that meeting that additional criteria under those categories that we are going to discuss for combat relation. Next slide, please, Amy. As I had discussed earlier, you cannot receive both CRSC and CRDP, and so you must elect to waive one. If you do not make an election, DFAS will pay you whichever one is going to be higher on the gross amount. So they're not going to look at the tax benefit of CRSC versus CRDP. They're just going to look at which one has the higher amount as a gross. Important to note that both of these benefits are paid in full month increments only. So if you get out in the middle of a month, do not expect to receive that benefit until the following full month of eligibility for that benefit. And there's going to be factors that are going in with this particular benefit. So factors such as your military retirement, your military pay, your rank, your years of service, other factors such as those are going to be the factors on which the amount that you could potentially receive will be based. And then importantly for military retirees is that CRDP is almost always going to be higher than CRSC, even though the CRDP is usually taxed. So one thing we'd like to say is that we will always look at it on a case-by-case basis, but usually what we find is the CRDP is almost always going to be higher. Next slide, please, Amy. Next, we're going to look at the categories of CRSC. And when we talk about the categories of CRSC, what we're really asking is the ways in which condition can be found to be combat related. Next slide, please. And now, under law, there are 5 primary categories of combat-related disabilities eligible for CRSC. These include injuries incurred as a direct result of armed conflict, injuries incurred through an instrumentality of war, injuries incurred in the performance of duty under conditions simulating war, injuries incurred while engaged in hazardous service, injuries for which you are awarded a Purple Heart, and 2 additional categories that the CRSC boards have recognized are presumptive conditions and secondary conditions. Next slide, please. Injuries as a result of a direct result of armed conflict. This is exactly what it sounds like. So it's any action in which a service member is engaged with hostile or belligerent forces. However, there must be a causal relationship between the armed conflict and the disability. As you'll see, it's simply not enough that the injury occurred in a combat or hazardous pay zone. Next slide, please. Some examples of injuries as a direct result of armed conflict include injuries from a rocket or mortar round, so indirect fire, or direct fire. Injuries resulting from enemy gunfire. Injuries not approved for CRSC include twisting your ankle while stepping in a pothole in a combat zone, but not while actively engaged with the enemy. As we suggested in the previous slide, it's not simply enough that the injury occur in the combat zone. There has to be a causal relationship between a direct result of armed conflict and the injury. Now, for instance, if the facts were different and a service member had tripped in a pothole while trying to evade indirect fire or direct fire, then that would be an example of injury as a direct result of armed conflict. Next slide, please. An NVLSP armed conflict success story. An Army Staff Sergeant deployed to Iraq 3 times as an infantryman in heavy combat areas, raided target houses, and he was repeatedly exposed to small arms fire, heavy artillery fire, and explosives. Suffered nightmares, of the traumatic events, intrusive memories, and emotional numbing. He was diagnosed with PTSD. The staff sergeant received CRSC for the PTSD under the armed conflict category. It's important, what we can see from this example is that it really illustrates that causal connection between the armed conflict and the injury, which in here is PTSD. And we can look to the factors such as the repeated exposure to small arm fire, the heavy artillery, the exposures to explosives, and those are the kind of connections that the boards will look for armed conflict. Now, I'm going to yield here and allow Amy Fulmer to step in for instrumentalities of war.
Thanks so much, Sean. As Sean said, I'm Amy Fulmer. I'm a staff attorney with NVLSP, and I'm going to pick up on some additional categories that qualify for CRSC. So the next category is instrumentalities of war. This includes a vehicle, a vessel, or device that is designed primarily for military service and is intended for use in such service at the time of the occurrence or injury. This category includes wounds caused by military weapons, accidents involving a military combat vehicle, injury or sickness caused by fumes, gases, or explosions of military ordnance, vehicles, or materials. This category can also include instrumentalities not specifically designed for military service, if the use of the instrumentality subjects the individual to a hazard unique to military service. So for example, being assaulted with a shovel by an enemy combatant. Whereas if it was an injury incurred due to a shovel because service members were horseplaying with each other, that would not qualify. As with a direct armed conflict, there must be a causal relationship between the instrumentality of war and the disability. So some examples of instances that would qualify: a hand being crushed by an armored vehicle hatch, or an injury by shrapnel on a grenade range. Now you'll note that says on a range. So instrumentalities of war don't have to take place on the battlefield. They can take place in training. It's not about the location where the injury occurs as much as it is about the thing causing the injury. As we've also covered previously, just being in a combat zone on its own is not enough. So for example, an injury from operating a forklift while in a combat zone would likely not qualify as an instrumentality of war. Here we have an NVLSP instrumentality of war success story. A veteran served in the Army as a wheeled vehicle mechanic and deployed to Iraq and Afghanistan. While pushing a Humvee backwards in training, it rolled over his leg, injuring his foot and his ankle. Other soldiers had to push the Humvee off of his leg. He received CRSC for foot and ankle conditions under the instrumentality of war category. So our third main qualifying type of condition are conditions simulating war. So disabilities resulting from military training, such as war games, airborne operations, grenade and live fire weapons practice, and hand-to-hand combat training. I will note that this does not include physical training or activities such as calisthenics, jogging, or recreational sports activities. So some examples are being injured while performing combatives training or hand-to-hand combat training, or being injured during a combat vehicle rollover training exercise. Injuries not approved for CRSC include mental or physical injuries incurred during a training exercise that is not simulating war, such as basic training in general, regular physical training, or training for things such as preparing to deploy, because that would not be simulating war. Here we have a NVLSP simulating war success story. In preparation for deployment to Iraq, an Army captain was participating in live fire vehicular training. The vehicle hit a ditch and he was pinned against the vehicle by another soldier with the magazine of a firearm protruding into his back. Due to the magazine in his back, he suffered a slipped disc, which led to disc disease and radiculopathy. He received CRSC for his disc disease and radiculopathy under the condition simulating war category. And the fourth main category is injuries incurred through hazardous service. This is not limited to any specific set of activities, but we most commonly see it approved for things like aerial flight injuries, parachute duty, demolition duty, experimental stress duty, and diving duty. As with the other categories, the injury or disease must be the direct result of actions taken in the performance of specialized duties. So for example, boarding a plane to go do a parachute jump and being injured while boarding the plane likely won't qualify, whereas a hard landing or hitting a head on the hatch when exiting the plane to parachute likely would. So some examples: injuring a knee while performing airborne duty. So this would be the hard landing example I gave, or otherwise becoming tangled in the riser cords. Again, serving in a combat zone alone does not qualify as a hazardous service for CRSC, regardless of whether or not the service member was receiving hazardous pay. As with the instrumentalities of war category, this is more about the activity being performed as opposed to the location that the injury occurs. So this can occur in training or in a combat area. And here we have a hazardous success story. A soldier suffered a hard landing while conducting parachute airborne training. The hard parachute landing resulted in the soldier incurring an injury to his back. He subsequently received CRSC for lumbar and cervical spine conditions under the hazardous service category. And the fifth main category that CRSC can qualify under are Purple Heart disabilities. So the Purple Heart is awarded to service members who are wounded or killed as a result of armed conflict. However, there does need to be sufficient causal relationship between the disability and the injury for which the Purple Heart was awarded. So it's not a blanket award where if you have a Purple Heart, all of your VA-connected, service-connected conditions qualify. We still need to show that the incident for which the Purple Heart was awarded is connected to the condition being claimed for CRSC. So additionally, we have combat-related presumptive conditions. So certain presumptive conditions automatically qualify as combat-related. And these are presumptive conditions associated with toxic exposure and exposure to burn pits, Agent Orange exposure, Persian Gulf War service, and mustard gas and lucite exposure. So the PACT Act covers burn pit exposure. This was passed in 2022, and it identified a set list of conditions that are presumptive for service connection, provided that a service member has at least 1 day in service in the covered locations, which is largely the Middle East. That has been greatly expanded to include numerous other conditions. Largely, it covers respiratory conditions and cancers. So that PACT Act created the presumption of service connection for multiple conditions, respiratory conditions and cancers due to exposure to burn pits and other toxins. As I said, the PACT Act includes cancers and respiratory conditions, and generally we see CRSC boards uniformly granting CRSC for PACT Act conditions, even if the VA has not specifically coded them as presumptive or TERA incurred. We also have VA Gulf War presumptive conditions. The VA is recognizing some medically unexplained chronic multi-symptom illnesses as presumed due to service in some locations with burn pits. The two conditions we most commonly see approved are irritable bowel syndrome and fibromyalgia, and the VA presumptive conditions are being awarded with CRSC with supporting medical documentation, irrespective of explicit VA coding as presumptive. And the final category in which a condition can qualify for CRSC is as a secondary condition. So a secondary condition is a condition that the VA has service-connected because it was caused or aggravated by another service-connected disability, so a primary condition. So example would be muscle damage of a calf due to a bullet wound being a primary condition, resulting in knee instability as a secondary condition. For a secondary condition to qualify for CRSC, the primary condition must be combat related under one of the categories of disabilities eligible for CRSC. If a primary condition is combat related, the secondary condition is automatically qualified as combat related and qualified for CRSC. This does not, however, include conditions that the VA has simply said are associated with another condition. Without the explicit secondary designation by the VA, which would be on a VA rating decision code sheet, most claims for secondary conditions are denied. Instead, claims may be granted as caused by the same events responsible for the primary or other combat-related condition. So now we're going to talk about the process of applying for CRSC and the appeal should an initial application not be successful. So step one would be to review military personnel files, military medical files, and any other documents for support that supports a combat-related determination specific to that condition. It's important to note that the CRSC board is looking for documentary evidence. So simply a statement of this is how I was injured is typically not going to be enough for them. So it's important to find those supporting documents in the record. Step two is to complete the CRSC initial application form, or DD 2860. Step three, and this is what we typically do, we'll draft a brief addressing each combat-related disability with supporting documents attached as exhibits. As I briefly covered previously, it's very important that there is supporting evidence submitted with the application. And then step four is to file with the branch from which the veteran retired. Army and Navy both have email options for submission. Air Force requires submitting via hard copy in the mail. The estimated wait time from submission of an application to decision from the board is roughly between 12 to 18 months. And then typically another 4 to 8 weeks after the decision is issued, Defense Finance and Accounting Service, or DFAS, will issue an audit letter that will detail the amount of benefits which are based on the military pay and may be capped. Some key supporting documentation: Purple Heart certificate and orders, a DD-214, VA rating decisions, medical retirement board documents for medically retired service members, performance evaluations that may show things like participation in combat patrols or having shot certain types of weapons, and then medical records. Some common myths. None of the following automatically qualify for CRSC. Seeing dead bodies. My buddy got CRSC for a condition or event similar to the one I'm claiming. The physical evaluation board and medical retirement process found that my condition was combat related. Now there's a slight exception there in that the Navy has a specific policy where if the physical evaluation board determined it was combat related, the CRSC board is supposed to also find that it's combat related. They generally apply that, although not 100% of the time. VA coded condition is related to combat. Oftentimes on a VA rating decision sheet, one of the things identified will be combat incurred. While that is helpful, it is not binding on the CRSC board because there's different definitions for the VA as to what combat related is and to the CRSC board as to what combat related is. And then surviving military sexual trauma or racial discrimination while deployed. As we covered earlier, it's not enough that the service member has been deployed to a combat zone and that that's where the incident occurred. It has to still fit into one of those boxes of CRSC combat related in order to qualify for CRSC benefits. Some common reasons for denial: no contemporaneous medical evidence. So for example, a degenerative back injury. The board may point to wear and tear, even if the wear and tear is from parachute jumps. What the board really wants to see is a specific event or events and supporting medical treatment records or documentation close in time to the event. So for example, just because a service member had 65 jumps over their course of their career and have developed a bad back and bad knees, because that's what happens when you have 65 jumps, that is typically not going to be enough to qualify for CRSC. The board wants to see a specific incident, a bad landing, a bad exit out of the aircraft, something to that effect. Anything that they see as wear and tear, even if that wear and tear sounds like it should fit into one of the categories, is generally not going to be approved by the board. Injuries that do not qualify as combat related. So sleep apnea. It is not one of the identified presumptive conditions, and we do not see the boards willing to grant CRSC for sleep apnea, with pretty much one exception. Well, two exceptions. One, sometimes the VA will connect the condition, so they will give a combined rating for, say, sleep apnea with asthma. Now, asthma is a PACT Act condition, and in those cases, we can argue that the asthma is PACT Act related and the CRSC board can't separate the two. And the other time we've seen that granted is when the sleep apnea is specifically identified by the VA as secondary to a combat-related condition. So for example, secondary to PTSD. And then the third main reason we see denials are that the evidence does not support exposure to the direct arm conflict. Well, that's not the only category. That is a lot of times the category we're seeking. A command statement can be helpful to corroborate combat events and may be helpful for veterans who do not have a combat badge, which we would identify as a combat infantryman badge, combat action ribbon, a combat action badge, or a combat medical badge. Also, any badge that has a V device or Valor device attached to it are considered combat badges. So if those are not in a veteran's records, it can be helpful to get a command statement to corroborate the combat events that they were exposed to. I would note that typically they're looking for a commander or witness that was on the ground experiencing the combat event with the veteran, not someone who's hearing about it after it happened. So what happens if the initial application is denied or partially denied? There's a CRSC appeals process. The CRSC you can request for reconsideration at the applicable branch. So that would be back to either Army, Navy, or Air Force, depending on which branch you served in. That is just a different form. Then you can appeal to the Board for Correction of Military Records for your respective branch. Also requesting CRSC, it uses a different form, but you're making the same arguments. And in some circumstances, it may be possible to pursue an appeal through litigation in court. And now I'm going to pass you back to Rochelle.
Thank you, Amy. We're going to turn now to the topic that was addressed in the Soto case, the effective date for CRSC. Next slide. So the CRSC statute has a very detailed scheme for defining the date when eligibility begins. And it's not just one factor. There are 3 separate dates that one needs to look at to find the effective date in the statute. So first, the VA date that they service connected the disability, that's an important date. And you cannot get CRSC benefits prior to being service connected. Another important factor is the date the veteran was retired from the service branch. And so, for instance, someone who's in the reserves or the National Guard may get service connected for various conditions, but they're not retired yet. They can't get CRSC until they're retired. And flipping that around, if they're retired on a certain date, but perhaps they don't get service connected for their asthma for another 4 or 5 years, they can't get CRSC for the asthma until they're service connected. So it's both of those, and whichever one is later. Then there's a third factor, which is the date of the law that created entitlement to CRSC. So CRSC was first enacted only for longevity retirees. Those are based on years of service, usually approximately 20 years. That became effective in May of 2003. So you cannot get CRSC as a longevity retiree before then. For medical retirees, it was not adopted and effective until June of 2008. So the law had to be in force, and you have to be both retired and service connected. And again, just to emphasize, if an individual is not retired, if they've just finished their term of service, they're not eligible for CRSC, regardless of whether they have conditions from combat. Next slide. So previously, in the previous slide, I talked about what the statute itself said. Now I'm going to turn to the practice that was enacted by the Department of Defense. So they imposed a 6-year statute of limitations. A statute of limitations is how far back can you go? And they based it upon another statute, not the CRSC statute. They based it on the Barring Act, which is a general law in regard to suits against the government and how far back can you go. And in general, there's a 6-year limit. And that was computed from the date of application. So regardless of when a veteran was retired, regardless of when a particular condition was service connected, this 6-year period was from the date of the application. Even though under the CRSC statute in the previous slide that we just looked at, they may have been eligible for an earlier period. Next slide, please. Longevity retirees automatically get CRDP, whereas you have to apply for CRSC, be found eligible, and so on. So usually CRDP comes first. And therefore, we're usually not seeing retroactive CRSC benefits being paid out. What will happen is DFAS will say, this is your CRSC amount, this is your CRDP amount. You pick, if for whatever reason, for tax purposes, it's more beneficial to you, the veteran picks CRSC instead. That's prospective. It doesn't go back. So while there may be exceptions, most of the veterans who are impacted by Soto and all these effective date issues, it's mostly medical retirees. Next slide, please. So now we're going to talk about the Soto case. Next slide. NVLSP and Sidley Austin filed a class action lawsuit in 2017, and our claim was that the Barring Act's 6-year statute of limitations did not apply to the CRSC statute because of all the details within the law itself that set forth when the benefits were to begin. In this litigation, the class was limited to veterans who were owed $10,000 or less. A notice was sent to approximately 9,000 veterans who had claims as of September 30th, 2020. Following the class notice, where class members had the opportunity to opt out, the court certified a class and issued judgment in favor of the class, but there was no mechanism established for how the Department of Defense would pay all the class members. There was simply a determination as to what the law required, and the district court ruled that the law required that the CRC statute's effective date scheme be applied and not the Barring Act's 6-year limit. Next slide, please. The district court was reversed by the Federal Circuit, but then the Supreme Court reversed them, going back to the decision. 2 reversals got us back to an affirmance of the district court's decision. And the holding is that there's no 6-year cap on retroactive CRSC payments. It was a unanimous decision of the Supreme Court written by Justice Clarence Thomas. And it's summed up in this quote here that, whereas here the statutory scheme involves a small group of particularly deserving claimants, it is not extraordinary to think that Congress wished to forgo a limitations period. So unlike the typical claim against the government that you have a limitations period, instead the CRC statute's own mechanism for determining when benefits would start, that precluded the specific statute precluded the general statutory provision, and therefore the Barring Act did not apply. Next slide, please. There's a separate litigation that was filed by NVLSP and Sidley. This was for veterans who were owed more than $10,000. That was filed several years later, and Soto was already on appeal, so the Carey case was just held in abeyance or stayed pending the outcome of all the appeals in Soto. And since it was just put on hold, no notice was provided to the class. There's been no decision in Carey, but in conversations with the Department of Defense, NVLSP and Sidley have been told that they are not going to try to litigate out the Carey case for veterans who are owed more. The legal claim is exactly the same. And so they have said that they are going to treat all veterans the same, regardless of whether they're owed $1,000 or $20,000. So both of these cases are now moving to implementation. There's no expectation that there'll be any more court hearings regarding what the law requires. The Supreme Court has unanimously stated that the Barring Act doesn't apply. And so DOD has informed us they will be applying that to all veterans, regardless of the amount owed. Next slide, please. NVLSP published our first version of our frequently asked questions. This contains a lot of the information in these slides. and that was in August of 2025. We are planning to update the frequently asked questions likely next week. I mentioned these slides would go up next week, so it's going to be a big week for putting more on our website where you can learn more about CRSC and the Soto case. So we're expecting to put out a new updated draft next week. Next slide, please. The court did not put in place any specific process for getting veterans the benefits they are owed as a result of the decision in Soto. The Army website is the only branch website that currently states anything about providing back benefits to veterans. And it states, no action required. The Army will update all CRSC claims, this is for Army veterans, automatically, and veterans should expect the process to take several months. They estimate approximately 7,000 impacted Army veterans, and the site is there. Next slide, please. So we have not seen anything in the Navy, Marines, Air Force, Coast Guard regarding implementation of Soto. Originally, all of the websites said that the Barring Act applied to CRSC claims. So we've seen the Navy, which covers the Marines, and the Coast Guard take that down. The Air Force still says, or the last time we checked, which I believe was like yesterday or the day before, it still said 6 years. And no one but the Army makes any mention of paying claims. There has been some guidance issued. This came out on August 20th. And the guidance says, effective immediately, the Department of Defense is instructed to cease applying the Barring Act to limit CRSC. The branches are being instructed to identify veterans whose retroactive awards were limited by the Barring Act and ensure they are compensated according to the effective date in the statute. And there's more details in this guidance about how to pay the various members of the class. Next slide, please. The guidance is not final. It specifically says it is interim, and that permanent guidance will be issued as early as practicable. Next slide, please. So the Army website says benefits will be provided over the next several months automatically. We think that there could potentially be delays in that prediction for how many months. So obviously, if enough staff were put on this project, it could be done very quickly, but our understanding is in general, DoD staff are being cut. We have not heard of, it's not that it's impossible, but we've not heard that additional staff are being hired to do these retroactive Soto determinations. So existing DoD staff minus whoever's been cut are going to need to do this. You can't just look at today's benefits and say, oh, person was denied 5 months, I'm just going to multiply it by 5 and give them the benefits they're owed. And that's because additional retroactive benefits are likely to be lower per month than current benefits due to cost of living adjustments and increased ratings. Many, many veterans have ratings increase over time. Pretty typical that as we age, our conditions get worse. So hypothetical here, we have a knee condition. Back in 2016, it was rated only 10%. Back benefits were limited to 2018. Maybe in 2020, that rating went up in 30%. So if you look at the amount of benefits now, it's going to be based on the 30% rating, not the 10% rating that was back in the time period that was improperly cut off due to the Bearing Act. So the bottom line here is that it's a unique look at the ratings. They can't just multiply out current benefits. And so it's going to take some time to look at each case and figure out what's the proper amount of the back benefits that were cut off due to the Barring Act. And so the CRSC boards need to go and look at that and then figure out what the ratings were and what the proper starting date is based on when they were retired, when they were service connected, all of those factors. And so it's going to take a bit of time, and there are thousands of class members. We know there were 9,000 back when notices were sent in the Soto class action, and many more have applied and been awarded CRSC since then. So while we don't have a number of veterans, we know that it's likely above 9,000, and that's just a lot of files to open. So based on our prior experience, where the court has said, this is the law, go ahead and change your decision because you didn't follow exactly what the law required. Our experience is that it takes several years, not several months. Now, again, I can't tell you how long it will take in this case. It depends on the resources that are allotted to this, but I can say that it is possible that there will be delays beyond several months, as was stated in the Army website. We also are just ending a government shutdown. That could also contribute to delays in implementation of relief here. The boards didn't operate fully for a few months. And so, we don't know whether that will also impact how quickly veterans will get their back benefits. Next slide, please. I want to go back over who is likely to get these back benefits. If you have not applied for CRSC, you are not entitled to any additional relief. You have to have been granted CRSC and qualified for a period longer than 6 years from the date you filed pursuant to all those factors in the law, but have been cut off at the 6-year mark due to the Barring Act. So these are the only people who are likely to get the back award. This is going to be primarily medically retired veterans who were cut off in this manner because, as I discussed earlier, longevity retirees most likely, for most cases, went prospectively, and so they didn't have this limitation placed on their back award because there likely wasn't any. Next slide, please. So we are hopeful, skeptical perhaps of a few months, but nevertheless hopeful that in the coming months, many veterans will get their benefits that they're entitled to as a result of the Soto litigation. Is there anything that a veteran can do to proactively seek these benefits? Reconsideration, which Amy mentioned, is an option for seeking additional conditions, appeal of a denial. You can also appeal the effective date in the original decision through reconsideration. There is no deadline for reconsideration. So even if you were awarded CRSC in 2017, there's no cutoff of when you can seek reconsideration. Is it possible to go to court? Well, the 9,000 Soto class members who received notice in 2020 were sent a notice that said they could not file individual suits. There may be some exceptions to that, but in general, if one got that notice, there could be prohibitions on individual suits. If you didn't get that notice, or there are some exceptions, it may be possible. It is unknown whether that will speed up payment or not, but those are both possibilities. Next slide, please. So while the August 20th guidance was generally very helpful to veterans who had Barring Act applied, it contained a new policy that is even more restrictive than the Barring Act. The guidance says that for decisions made on or after August 20th, the effective date is the date on which the completed application was received. So whereas under Barring, it was 6 years prior to the receipt of that application, under this guidance, this interim guidance issued on August 20th, it's cut off at the month, not 6 years back, but at the month that the application was received. It says a subsequent award for additional disabilities is effective on the date the completed application for those disabilities was received, with no definition of completed application. But likely that means the form, the 2860 or a reconsideration form listing additional conditions would be considered the date of application. That was the way it was interpreted for Barring. It wasn't the date of submitting the evidence that got one approved. It was the date the form was initially filed, was the way they were computing the back award under Barring. Next slide, please. In NVLSP's opinion, the limitation to the month of application does not comply with the CRC statute. And so this month we have filed a class action complaint, Doe versus United States, in the Court of Federal Claims, challenging this new policy limiting back awards to the month of application as violating the text, structure, and purpose of the CRC statute. And the complaint seeks payment to class members of retroactive CRC benefits wrongfully withheld due to the guidance. Next slide, please. So if you would like assistance from NVLSP's Lawyers Serving Warriors program, I encourage you to go online. You can apply for assistance with CRC. We also do discharge upgrades and medical retirements. The best way to get into our system is going online and applying. If that is difficult for you, you can email our intake at lsw.intake@nvlsp.org. We have a phone number, but we do not answer live. You can leave a message on our phone number, at our phone number listed here, 202-265-8305, option 5. But again, I recommend you apply online. Our process is that we obtain full medical, VA, and personnel files, and we screen for our program requirements. We do not have resources to accept all requests for assistance. And as I mentioned at the beginning, we are not a lawyer referral service, and we only handle a limited number of types of matters. So if you apply online for assistance with a divorce, that's just not a service that we provide. Next slide, please. And that gets us to the end of the presentation. We have a few minutes. As I stated earlier, we are not going to take questions about individuals' facts and their cases. But if there are general queries, we have a few minutes. Amy, Sean, I don't know if you see if there are any questions coming in.
Hi, Rochelle. Yeah, we did have one question earlier in the presentation. Because there is no PACT Act burn pit presumptive conditions category on the DD 2860, how would you, or what category would you put those conditions under?
That's a great question. So in general, the Army and the Navy code those as instrumentality of war. The definition of instrumentality of war includes fumes and gases and that's how they code it. The Air Force generally codes it as Gulf War. If you check on the DD 2860, either instrumentality of war or Gulf War, I think that it would be a successful application. I generally do not see applications denied based on which category you check. I generally see applications for PACT Act conditions like asthma awarded, and then they pick what category, but I would say instrumentality of war or Gulf War. Amy, you're saying a question came in?
There is a question. It's kind of outside the scope of CRSC, CRDP. It's asking about what can legally be done about having to give up military retirement benefits when you're receiving VA benefits, which I agree is not great, but outside the scope
that's Congress.
Yeah.
So that's not a lawsuit. The only thing that can be done about that is a change in the law. So that complies with the law. And if you would like a different law, then it needs to go to Congress. That's not something that can be litigated. So if there aren't any further questions, I will thank you for attending, and keep an eye on our website for more future developments, and let us know if you want additional assistance. You're welcome to apply for our services. So with that, I will end the webinar, and thank you to Sidley for hosting us.